Start. This petition under Article 32 read with Article 129 of the Constitution of India seeks initiation of suo motu criminal contempt proceedings against respondent number 4 Nishikant Dubey for having made deliberate and scandalizing remarks against the Supreme Court of India and the Chief Justice of India for a direction to the Union of India Ministry of Home Affairs to lodge a first information report under the Bharatiya Nyaya Sanhita 2023 and for a direction to the Union of India Ministry of Home Affairs to issue an advisory to all chief secretaries to curb hate and provocative speeches by political parties and their leaders relating to the Waqf Act 2025 and its hearing before this court. Full stop. Change. Normally, this bench would not have heard this matter, but as we are not inclined to issue notice and the Waqf matter was heard by the two of us, we would dispose of the writ petition with some observations and accordingly we have proceeded to consider the issue. Full stop. Change. Judicially pronouncements result in an order or a decision which may aggrieve a party of sometimes a section of the public. Full stop. Critical analysis and objective criticism of an order's reasoning or even its outcome is protected under the fundamental right or to free speech and expression under clause 8 of article 19(1) of the Constitution of India. Stop. The power of criminal contempt, however, is exercised by courts when publication by words spoken or written, by signs or by visual representation or otherwise, in terms of clause C of section 2 of the Contempt of Courts Act 1971, is with the intent of scandalize or lower the authority of the courts or tends to scandalize or lower such authority, prejudices or interferes or tends to interfere with the due course of judicial proceedings or interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any manner. Full stop. Exercise of the power of contempt, nevertheless, is discretionary. Full stop. Change. We have examined the contents of the assertions made by respondent number 4, which no doubt tend to scandalize and lower the authority of the Supreme Court of India, if not interfere or tend to interfere with the judicial proceedings pending before this court and have to tendency to interfere and obstruct the administration of justice. Stop. The statements made reflect the clear intent to impute motives to the bench itself by naming the Chief Justice of India as responsible for all the civil wars happening. Full stop. In India, and in order to incite religious wars in this country, it is only and only the Supreme Court that the responsible. Section 3 and 4 of the Act carve out exceptions which prime facie are not attracted. Stop. There is no civil war in India. Full stop. Change. In our opinion, the comments were highly irresponsible and reflected a penchant to attract attention by casting aspiration on the Supreme Court of India and the judges of Supreme Court. Full stop. This apart, the statements show ignorance about the role of the constitutional courts and the duties and obligations bestowed on them under the Constitution. Stop. At the same time, we are of the firm opinion that courts are not as fragile as flowers to wither and wilt under such ludicrous statements. Stop. We do not believe that the confidence is and credibility of the courts in the eyes of the public can be shaken by such observed statements, though it can be said without the shadow of doubt that there is a desire and deliberated attempt to do so. Full stop.